I'm going to hand you over to Jon. He is from the northern part of England, so if anyone doesn't understand him, just tell him to speak a little bit slower, okay?
Yeah, my accent is really bad, so I will try and go as slow as I can.
Okay.
Thanks, Dan. So as Dan mentioned, whether you are a client or a contractor, one of the things to consider is to have a good contract in place. This will help to deal with any issues that you might face on site. There are many contracts to choose from, however, FIDIC is widely used internationally. FIDIC was produced due to difficulty in using unfamiliar contracts around the globe. It was developed by the International Federation of Consulting Engineers, which is now based in Switzerland and has a membership of over 60 countries. It regularly updates and issues revised contracts, and due to this, FIDIC has become one of the leading contracts in international engineering and construction projects. Basically, you can go online and you can download a FIDIC contract template. Obviously, there's a cost associated to it, and you can fill that contract in, and you have the basis of a contract to start from. However, FIDIC is a suite of contracts, and the contracts come in all different colours depending on its type. Generally, in fit out, we're dealing with green, yellows, and red contracts or FIDIC contracts. So there's the green book, which is a short form of contract, which usually refers to one of the other FIDIC contracts, and it's for small value projects. There's the red book, which is for construction works where the design scope is the responsibility of the employer. There's a yellow book, which is suitable for projects where the contract has the majority of the design responsibility. Basically a design and build contract. And there's the orange book, which was the first design and build contract released by FIDIC. It's intended for use for turnkey contracts, where the employer's requirements usually include provision of a fully equipped facility ready for operation at the turn of a key, so including furniture, everything is included in that. There's a silver book, which is also for turnkey projects, which places significant risks on the contractor. It's generally used for power plants, factories and infrastructure projects, development sort of thing. There's the pink book, which is the adaptation of the red book created for basically multilateral development banks. And there's the gold book, which is FIDIC's first design and build and operate contract. So it's obviously kind of moving along with the times. FIDIC's generally divided into two parts. Part one consists of the general conditions, such as the general terms of the contract, issues and rights and obligations of each party, procedure for payment, variations, certificates, and dispute resolution. Part two of the contract is the conditions of particular application. It's used to introduce the project-specific clauses, such as language of the contract, probably not Geordie, choice of law, the name of the person or firm appointed to act as engineer or employer's representatives, other terms, and there's usually an appendix in there, which will give sample documents of the project to use, such as kind of permits and LOAs and things like that. One of the things to consider is the priority of the documents. It's important to prioritize these documents to minimize any grey areas. So for example, your drawings might suggest using a veneer, whereas your specifications might suggest using a laminate. Now, if you prioritize these documents so that the specification is higher than the drawings, you then will look at the specifications first. If the specification says laminate, then you'll use laminate in the contract. So it is quite important to make sure that these priorities are in the right order and has been considered in that order. There's also normally a particular conditions section in the contract. There can be a combination of like amended clauses, so someone has taken the FIDIC clause and amended it slightly to suit the project, or additional clauses, basically just to customize that contract a little bit more to kind of be in line with the project or the client. Obviously, payment terms, liquidated damages and things will all be mentioned in there. But one of the main reasons of using a contract, especially with FIDIC, is to reduce the amount of ambiguity in the contract. The FIDIC suite generally swings any ambiguity to the contractor's favour, or if it's a contractor giving it to a subcontractor, then the subcontractor's favour. So generally the person writing the contract needs to make sure that there's no ambiguity in there, because it could go against them. But it does have a multi-tier resolution process in FIDIC. So basically the first step for disputes would be submitted for adjudication before an engineer or dispute board. If either party is dissatisfied with that, there's basically a period called the amicable settlement period. This can go on, basically is kind of stipulated in the contract, but can go on for a few weeks to a couple of months. If the parties are not able to settle during this amicable settlement period, then basically the final stage is to go to arbitration. And FIDIC contracts provided the default position that the arbitration rules of the International Chambers of Commerce should apply in the arbitration of disputes arising from the contract. Then following that, if that can't be dealt with, then it would go legal to court. But one of the things to note is that FIDIC does not overrule any local laws. So if a project does go to court, then the local law will precede the contract, and that is where that contract or that project is being carried out, rather than where the person is from. So if it's an American contract in the UAE, the UAE law will come into place. So if Dan can just flick over to the next slide. Obviously one of the contract items that will come up over the next few months is going to be force majeure. So clause 19 of FIDIC 1999, force majeure is principally identified as being an exceptional event or circumstance which is beyond the party's control. The party could not have reasonably anticipated, the party could not have reasonably avoided, or which is not substantially attributable to the other party. All of these things must be kind of in there for it to be force majeure. So force majeure, or the act of God, which is generally known as, has been repeatedly applied to earthquakes, volcanic eruptions, floods, heat waves, any other unforeseeable natural incidents. It also includes war, riots, chaos, slowdowns, etc. The UAE Civil Code sets definition and boundaries of a force majeure event and the consequences that it triggers. The concept of force majeure may be pursued by a party to a contract as a matter of law. It is a mandatory rule as opposed to a default rule, even without being recited in a contract. So no matter what is in your FIDIC contract, the UAE law will overrule it. The UAE courts interpret force majeure very narrowly. A force majeure event must take the contract literally impossible, unforeseeable and uncontrollable before it is accepted. So obviously one of the reasons that we highlighted force majeure is in these unprecedented times, we will definitely see a rise in force majeure claims due to the coronavirus. Obviously in these early stages, no cases have been reported, but we can expect the UAE to take a tough stance against these force majeure claims. So the World Health Organization declared the threat from coronavirus on the 31st of December 2019. So any contractor looking to invoke force majeure on a project that was signed off after this date may not have a case because it could then have been foreseeable. So the UAE is not allowed, the UAE has also not allowed construction to continue, or has allowed it to continue, I should say, sorry. So again, any claims will be unlikely because you can actually go to work. So it'll go on a case-to-case basis. It could also affect the clients, so that any client looking to cancel or postpone a project, as they may still be liable, because again, if it was signed after this date, then it could have been foreseeable. So I think the only kind of things will be is the client and the contractor having an amicable agreement saying, okay, this wants to go on hold, we'll pay you this, or vice versa, the contractor turn around and saying, look, I can't get your, like for example, I can't get your FF&E because it's come from China, and there's going to be delays in the lead-in times because it's going to take 12 weeks now instead of 8 weeks. So again, there can be discussions backwards and forwards which might allow the contractors to build a claim and the clients to kind of do something. But I think it's going to be quite interesting over the next few months to years to see what happens with force majeure.